Hi, my name is Richard Primus, and I teach constitutional law here at the University of Michigan Law School. As we all remember, in the very beginning of his administration, President Trump issued an executive order barring the entry of refugees into the United States for a certain period of time, and also barring entry to nationals of 7 specified countries. The order was of obviously questionable legality from the beginning. And as soon as it was issued, huge numbers of volunteer lawyers went to American airports where international flights were coming in and spent the weekend lawyering, including overnight, to try to help people who were being detained as they arrived at the airports get out of custody. Last week, a federal district judge in Washington state entered a temporary restraining order halting enforcement of the executive order, having found that it is likely unconstitutional. And last night, a panel of the U.S. Court of Appeals for the Ninth Circuit upheld the district court's ruling. The Ninth Circuit's ruling seems right. There are at least 3 significant constitutional problems with the order, and there may be other legal problems with it too. The 3 constitutional problems that the Court of Appeals noted are these. The first is a Fifth Amendment issue. The Fifth Amendment promises each person that they will not be deprived of life, liberty, or property without due process of law. The amendment speaks of persons, not of citizens. There are many circumstances in which non-citizens are entitled to the rights of due process under the Fifth Amendment. And at the core of the due process right, the courts have long said, is the right for notice and an opportunity to be heard before an adverse action is taken against you. This executive order had the effect of barring re-entry into the United States for lots of people who already hold valid visas who are temporarily out of the country. That is to say, they were denied the liberty of re-entry to which they were already entitled. And they were denied without notice immediately, and they were denied without any opportunity to be heard on the subject and to contest their exclusion in individualized hearings. The Ninth Circuit Court of Appeals said that's likely a serious constitutional problem. Then there's a First Amendment issue. Under Establishment Clause doctrine, the government is not allowed to take actions that favor one religion over another religion. And the Court of Appeals said this order looks like it is motivated, at least in part, by anti-Muslim animus. Now, it's certainly true, as the administration's lawyer argued, that this order doesn't affect all Muslims. And it's also true that the countries from which travelers are barred are, in one way or another, countries of concern, have been identified as countries of concern by the U.S. government previously on issues of terrorism. But it's also the case that if an action is taken for reasons of anti-Muslim animus, it's unconstitutional under the Establishment Clause. And there are many reasons to think that that animus motivated this order, including the way that the president and other senior officials in the administration talked about the order and talked about their intention to issue the order, among other things, as a Muslim ban. The third constitutional problem is an equal protection problem, technically a Fifth Amendment due process problem, but as the lawyers know, we speak about that as an equal protection problem in the federal context. Once again, the problem is about animus against Muslims and discrimination against that group as such. These are all serious constitutional problems, and the Court of Appeals held last night that the administration is unlikely to be able to defend the order against constitutional attack on those grounds. There's another aspect to the case that's very important to consider. The federal government claimed in the proceedings that the court should not review the executive order at all. Their claim was, in issues of national security, the president has unreviewable discretion to act, and the courts should not second-guess his actions. It's true that traditionally courts have deferred significantly to presidential decisions on national security, partly because the president has a large expert staff and much more information about national security matters than the courts could possibly hope to have or to analyze. He has intelligence agencies and career diplomats and lots of quiet contacts with foreign officials. And for that reason, among others, courts have generally figured, in the national security context, the president knows better. But courts have never said that in a case where they don't think the president knows better, and they think the president's behavior is unconstitutional, that they would not review the president's actions. And one of the noticeable things about this executive order is that it seems to have been issued with no expertise brought to bear at all.